And Clwyd.
Mr Deputy Speaker, I rise to speak against Clause 151, restriction on issue of arrest warrants in private prosecutions. I do so as Chair of the Backbench All-Party Human Rights Group, of whom my friend, the member for Carl-Shalton, is the Treasurer. And I'm hoping that my arguments will prevail upon him this evening and that he will also see that to change this particular situation would be invidious. Mr Deputy Speaker, much of our criminal law is territorial. Certainly, he's already changed his mind, Mr Deputy Speaker.
I thank the Honourable Lady for giving way. Would she agree with me that if the DPP takes on this responsibility and is given the resources to ensure that when a request for an arrest warrant is made, that he or she is able to process that in a very short period of time, that in fact I think possibly all of the concerns that she may have about this proposal will go away? And if they're not going to go away, could she explain why?
I'm able to develop my thoughts. Mr Deputy Speaker, much of our criminal law is territorial, applying to acts done in England or Wales or by the British people. But in relation to crimes such as grave breaches of the Geneva Conventions Act 1957, torture and taking hostages, we have agreed to prosecute them here, wherever or by whoever they are committed. This is universal jurisdiction, intended by all the countries who accede to it to ensure that there is no international hiding place for perpetrators of grave crime. We have a duty, Mr Deputy Speaker, to seek out the culprits and either to extradite them or to prosecute them here. One example is that an Afghan warlord in 2005, Zardad, was successfully prosecuted in the UK for torture offences abroad. In the UK, it is not only the police who can initiate proceedings. Any individual can apply to a magistrate for a summons or warrant to bring someone to court. The test for the magistrate is whether there is some prima facie evidence of an offence by the person named. Many serious offences can't go beyond this stage without the Attorney-General's consent. Mr Deputy Speaker, I have some little experience of this, having chaired Indict, the human rights organisation which gathered evidence for 7 years against Iraqi war criminals. And the fact is, of course, that many of those criminals subsequently are either appearing in an Iraqi court or have already been sentenced. And I don't have time here now to go into what happened there, but it is extremely difficult under the current situation to actually get an arrest warrant. It took 2 years just to discuss the case of Tariq Aziz with the Attorney-General, with Scotland Yard, thrown back to the Attorney-General, and we didn't get a decision. Now, there was the strong possibility that Tariq Aziz, who travelled a lot, might have come to this country. He might have come to spend Christmas, for example, with George Galloway, because, of course, in the past, George Galloway spent Christmas with Tariq Aziz. Now, we did not manage to get that arrest warrant, and English law, I would say, does not allow arrest warrants to be granted on flimsy evidence. Our evidence was very strong indeed, and we still couldn't get an arrest warrant. Only 2 of the 10 private arrest warrant applications made in the past 10 years have been granted. So nothing needs fixing, as nothing has been broken. So, Mr Deputy Speaker, universal jurisdiction is a vital, agreed-upon basis for tackling impunity against those states who don't sign up to the International Criminal Court.
My honourable friend, who clearly does know what she's talking about, I don't know if she was as dismayed as I was by the Home Secretary's clearly not knowing at all what she was talking about at this point, when she was asked the question about what standard of evidence the the DPP would require. Is it the prima facie test? Is it the full code test by the prosecutor, or something in between? If the implication is, and perhaps she would hope with me that the government front bench will clear this up in winding up, if it is going to be a full prosecutorial test, then that means effectively that no warrants will ever be issued, because there will not be that standard of evidence gathered at the arrest stage.
I'm grateful to my honourable friend for reinforcing that point, which I attempted to extract further information from the Home Secretary. But I'm afraid I didn't get the answer, and I hope, as he said, that perhaps in the summing up, that could be explained further. Mr. Deputy Speaker, the 1949 Geneva Conventions require us to seek out and prosecute absolutely anybody suspected of committing war crimes. Similar duties exist under the Torture Convention, where we also have a duty to apply criminal law uniformly. A special legal or procedural system for those cases, different from the rest of criminal law, could breach that obligation. Victims securing the arrest of visiting suspects fulfil an important rule of law purpose. No state interference should bar their access to court. As Lord Wilberforce said in 1978, perhaps I could finish what I'm saying and then I'll give way. As Lord Wilberforce said in 1978, the right to bring private prosecutions remain a valuable constitutional safeguard against inertia or partiality on the part of authority. Lord Diplock similarly described it as a useful constitutional safeguard against capricious, corrupt or biased failure or refusal of those authorities to prosecute offenders against the criminal law. I'm
very grateful to the Honourable Lady for giving way very generously. Does she not accept that many other countries with similar legal systems to ourselves, I cite, for example, Canada, have established a similar system whereby, in the Canadian context, the Attorney General or Deputy Attorney General has to give leave before the exercise of their universal jurisdiction power, and many other countries have similarly fettered the misuse of universal jurisdiction, which has often taken the course of party political or other politically biased purposes, and they have not had any difficulties in the regards of what the Honourable Lady is saying. Where Lord Diplock and others refer to interference of the state, they did not apply it to this test.
The honourable gentleman will seek to catch the Speaker's eye. He obviously has a speech in the making. But I would say that from my experience of trying to get an indictment against some of the Iraqi war criminals in other countries, in Sweden, in Norway, in Switzerland and in Belgium, the closest we came to getting an indictment was in Belgium. But it was thwarted at the last moment because the Belgians, somebody brought an indictment against Sharon, and the Belgian government changed the law. So sometimes the pressures can be very different, and obviously we don't have time to go into them in detail now. But certainly.
The Canada's been mentioned. Would my friend agree with me that the difference between what is being proposed here and Canada is that in Canada, the DPP is entitled to appear, is entitled to present evidence for or against the issue of a warrant, but the decision is a judicial one. What is being proposed here is wholly different, as perhaps the right honourable gentleman opposite doesn't understand. The decision is made by the state before the court has a chance to consider the matter.
I'm very grateful for my honourable friend's expert knowledge on this issue. Mr Deputy Speaker, senior district judges are trusted to deal with highly sensitive terrorist and extradition cases and are very highly thought of. And I'd like to hear anybody say that they're not highly thought of. And their role should not be undermined. And that is precisely what the government are attempting to do. These judges are known to have thrown out cases against Israeli defence ministers, Moffas in 2004 and Barak in 2009, plus several cases against Mugabe. 8 refusals out of 10 means a system is robust enough to weed out illegitimate cases already. Indeed, there is not a single example of the current system failing to filter out cases that are an abuse of process. What is the evidence that the judge acted wrongly in the 2 cases in question? Does the Crown Prosecution Service have a view? Perhaps we'll hear. Some people, of course, are wildly exaggerating the real impact of the current law on them and officials from other countries. We know very well that many people from other countries who are presently in government, presidents, prime ministers, foreign ministers, and perhaps sometimes defence ministers, are free from any kind of arrest warrants of this kind. They can travel freely. In fact, absolute immunity applies to serving presidents, prime ministers, foreign ministers, and so on. So I don't know what the problem is, Mr. Deputy Speaker. It's a problem of the government's own invention, and I'm sorry that my front bench seems to be going along with them at the moment, and also the partners in the coalition. He might like to indicate whether he's changed his mind again, are also going along with. I think they're misled, and I think we do a disservice to the very many people all over the world who have been injured in some way by some of the people who clearly can be identified as war criminals.